it is sickening. It makes me want to vomit that this is what we're supposed to call justice system. I do not respect this woman. She should not be a sitting judge. She is a danger and a menace to society, and she needs to be voted out. When the other shoe drops, you will see some serious damage done to the Albert and the McCabe families, because once the feds get a hold of you, that means they have something. They never move in blindly. Well, hello everybody, and welcome back to your favorite show on the internet, Raw Law Unfiltered, with your favorite host, the DUI Guy Plus. Today we are going to continue with the masterclass closing argument of Alan Jackson in the Karen Reed case in Massachusetts. For those of you who are joining us after watching part 1, you may remember Jackson has just finished talking about the taillight and how it was intact at 5:07 a.m., allegedly 4.5 hours after she hit John O'Keefe. And a police officer who's not connected to Canton or the Massachusetts State Police testified that the taillight had a piece missing, but it was not broken to the entirety that it was here, leading us to assume and deduce by deductive reasoning that there's only one other entity or even person with the Massachusetts State Police Department, Michael Proctor and Yuri Buchanan, also known as Yuri Bukaki, who have concocted this scheme to break off pieces of taillight and scatter it. Let's continue.
You'll recall that after John's body was discovered, Lank, a very good friend of the Alberts, walked into Brian Albert's house and had an off-the-record meeting with him. No one's ever going to know exactly what that meeting was about, what they discussed, because that interview, like everything else in this case, it wasn't recorded. It wasn't memorialized.
So suspicious.
But we do know that shortly thereafter, the Canton Police Department was recused from the matter entirely, and the case was assigned to one Michael Proctor. You have to believe that when the Alberts found that out, they thought they hit the lottery.
And that is because they're buddies from long time ago, high school. Since this has happened, by the way, Michael Proctor has been relieved of his duties, and he is no longer in the same capacity that he was before. He's not investigating major crimes anymore. We don't know what his fate is just yet, but what we do know is that Michael Proctor is no longer performing the same duties as he did before. And you know what? That is one step towards victory.
They thought they hit the lottery. What are the chances? The department where my brother works, that would have been great to investigate this case, but that department's been recused. That's tough luck. But the guy who catches the case is Michael Proctor, a guy we go back with for decades. At such a break, they probably thought, when this is over, we need to get that dude a gift. Oh, wait a minute. They didn't think that. They said it out loud. But still, you've got to imagine that the Alberts had to be stressed, what with that whole thing about a dead body being on their lawn. That might get some attention, and they had to be wondering, will he set up a crime scene? Is he going to come into the house? Is he going to search the house? Is he going to send in a forensics team? Is he going to interview witnesses? Is he going to take us to the station? Will he take our phones? Will he look at our communications? Will he look at our Google searches?
Yeah.
Will he look at our early morning phone calls? Is he going to look in the basement?
Yeah.
And Michael Proctor answered every single one of those questions resoundingly. Nope. He's a Boston cop too. And with that, Michael Proctor didn't draw a thin blue line. He erected a tall blue wall.
And I love that because we've heard the phrase, the thin blue line. Officers protect other officers. There's this thin blue line, this invisible thin blue line. Michael Proctor went way above and beyond, creating just I'm going to be protecting one of our own thin blue line. He erected a tall blue wall. Not only does it rhyme and it's catchy, but it's so true. A tall blue wall has been erected in order to make sure that the truth never comes out, to protect the Boston cop, Brian Albert, and his family.
A wall that you can't scale. A wall that Karen Reed certainly couldn't get over. a wall between us and them, a place you folks are not invited. We protect our own. It's us or it's them. And by the way, who's she after all? Nobody. An outsider. This is going to be easy. Or so they thought. Let's look at what Michael Proctor actually did and did not do in this case. One of the consistent issues that's come up throughout this trial is how evidence always seems to be changing and evolving when in Michael Proctor's hands or somebody in his orbit. If it happens once, let's chalk it up to a mistake. Twice, it's starting to look a little bit like incompetence. If that happens every single time, it becomes intentional, which means it becomes corruption. The defense spent some time, we spent some time discussing the tow time that Michael Proctor swore to in affidavits. There was a reason that we believed it was so important, and I want to talk about that for just a quick second. Because this was a concerted effort by Michael Proctor to falsify the time the car was seized, so that no one would know that he actually had possession of the car before the first pieces of taillight were ever discovered at the scene. But he got caught. And when he did, the best he could come up with was it was a typo. Like a dozen times, a typo. You'll remember what that testimony was. The truth is that car was in Michael Proctor's possession from about 4:12 in the afternoon. He said it was 4:16 when he finally had to tell the truth or some version of the truth. Those first pieces of taillight were not found until after 5:45 p.m. That is the very fact that Michael Proctor was trying to hide by those falsified affidavits, saying he didn't seize the car until 5:30. But that wasn't Michael Proctor's only manipulation of the investigation. What about Brian Loughran? You met him. Michael Proctor did his level best to not just hide evidence, but to hide human beings from you and from us. Michael Proctor was informed that the plow drivers were out that night. There would be a witness, potentially along 34 Fairview, at the exact times in question.
Lucky.
Even Michael Trotta expressly told Michael Proctor that 34 Fairview had in fact been plowed that morning, and by whom.
Yep.
Proctor not only did not interview Brian Loughran, he never disclosed his name in a single report. He hid him. This is a witness who was literally on 34 Fairview at the time in question where a body was found on the lawn. Wouldn't you want to get the truth from an eyewitness?
Nope.
Wouldn't you want to seek that out? Not if you're Michael Proctor,
Nope.
a close friend of the Alberts. If it were up to Proctor, you literally never would have heard of or from Brian Loughran. That's a scary prospect. I want to touch briefly on the additional physical evidence, or some additional physical evidence presented by the Commonwealth in this case. You'll recall Christina Hanley. She established to a scientific certainty that the glass on the bumper, which was told to you in opening statement, was going to have something to do with this case. The glass on the bumper was going to match that cocktail glass. She told you unequivocally the glass on the bumper did not match the cocktail glass. They came from two different sources. The glass on the bumper has nothing to do with the cocktail glass. So that glass on the bumper had to get there somehow. It didn't get there by being broken from the cocktail glass. See the point? It had to get on the bumper somehow. It didn't jump up there by itself. And what's really interesting is that there was one piece on the bumper, only one, that matched something else in the case. It was a perfect match to a piece of glass that was supposedly found at the scene. Who do you think had possession of that matching glass? Michael Proctor. So the glass on the bumper had to be placed there, and the only person who had anything close to matching the pieces that had to be placed there is Michael Proctor. You do the math. That leads us to the magic hair. The Commonwealth spent a lot of time bringing in experts about mitochondrial DNA and maternal DNA lines and comparative analyses, and all that sounds really great and really sciencey, except for the fact that it just doesn't matter. Why? Because you would have to believe that that little hair, tiny, tiny little hair, barely perched on the side of that SUV survived nearly 75 miles of a raging blizzard outside. that would be a magic hair indeed. That magic hair means nothing. The DNA means nothing, and that's because the hair was from somewhere else. It certainly was not from a motor vehicle incident at 34 Fairview on January 29th. That hair was placed there. The DNA on the outside of the taillight housing also merits very little discussion. John's DNA would be expected to be found all over that SUV, inside, outside, the exterior, the interior, everything he touched would have had his DNA on it. Here's what's actually important about that DNA. No DNA was found on the interior of that taillight. The taillight that they now claim crashed into his arm and shattered.
Huge.
No blood was found anywhere on that taillight or any taillight pieces. And no tissue was found anywhere on that taillight or any taillight pieces. But we're to believe that that taillight literally exploded on John's arm at 25 miles an hour with 1,000 pounds of pressure.
Makes no sense.
We talked about the evidence doing very funny things when in Proctor's possession or the possession of somebody in his orbit. Now think about the videos that you saw. How many videos appear to be somehow manipulated or altered? Just about every single one of them. Look at the video of the Sally port. Let's take that one for example, that grainy one. It's missing the exact time that would show the condition of the taillight when it was pulled in to the Sally port. Pretty important time, wouldn't you think?
Yeah.
Did someone not want you to see what the condition of the taillight was at that exact time? But the good news is there's a second video. It's much clearer. And it's from the same time frame. We didn't get that one for about 2.5 years into the investigation. Literally, it was after the trial started that that one was turned over.
Unbelievable.
And this is important. The Commonwealth introduced you to a person by the name of Yuri Buchanan. They presented video showing what was clearly the right side of the car. They asked questions about the right side of the car. You'll recall, Mr. Lally asked Sergeant Buchanan, did you or Trooper Proctor ever go at, or near the right side of that taillight? And while he was asking the question, what appeared to be the right side of the car was looking at you. The video was still up. Buchanan paused, turned earnestly into the microphone, stared at you and said, never. We never went anywhere around that taillight. While he was showing you the right side of the car. And that trick might have worked until we got up to cross-examine him. And only then, on the second day of his testimony, did he have to admit that the video was actually inverted. It was backward. And it was cleverly inverted at that. The timestamp had the proper orientation, which means that timestamp had to be removed, the video inverted, and the timestamp placed back on it. Which means that was done intentionally.
Yep.
That was not a mistake. And when caught in that obvious fabrication, Buchanan doubled down and said, it's exactly the same. You remember that back and forth. It's exactly the same, he said, as if we're stupid. Is it exactly the same? Or is it exactly opposite?
If you remember that testimony, Yuri Buchanan truly was a monster who helped Michael Proctor in this cover-up. He sat there with a straight face. I remember this cross-examination by Alan Jackson. He said, this is not the actual video, is it? And he was like, yes, it is. No, this is an inverted video. Okay, well, it's the same thing. It's not the same thing, Alan Jackson kept prodding. It is absolutely not the same thing. It is a video that has been inverted. That's not reality unless you live in some parallel universe. He confronted Yuri Buchanan and he was just like, this, I can't call him a police officer. That's giving him too much credit. Hopefully soon to be former cop is sitting there going, no, this is what happened to an inverted video, folks, to an inverted video. You can't make this stuff up. This is beyond the pale. This is unbelievable stuff. Aidan Carney, also known as Turtle Boy, said that there's going to be a Hollywood movie being made on this. I'm not surprised at all. This screams the hallmark of it has to be memorialized in more ways than one. There should be a book written. I know it's not over since there's been a mistrial in this case, and this closing was powerful enough to at least sway one person. I'm sure there are multiple individuals who believed she was not guilty. I hope for our sake, if we ever do get a polling of the jury, we're going to get the real numbers, and when we do find out, I have a gut feeling that it's got to be at least like 8 votes for not guilty, if not 9, 10, or possibly even all the way to 11. We know it's not 12 because they hung, but my vote is somewhere between 10 and 11 based on the jurors' observations. But not my own. This is all hearsay, unfortunately. I was not able to be there to sit through. I had other things that I had to take care of, but if and when the jurors ever do come forward, we are going to finally get a chance to hear with our own eyes and ears what was going on in that deliberation room. And I can't wait for that to happen. I think it's going to be absolutely enlightening for us.
Ladies and gentlemen, you were lied to. There is no other way to say it. It's inexcusable. It's abhorrent. But it's also a paradigm of everything that the investigators have been willing to do in this case. Lie, obfuscate, manipulate, alter. And when they're caught, they just excuse it away. Doesn't matter. It's the same thing. What's the big deal? Just look the other way. And don't forget, Buchanan is Proctor's supervisor. And he was in that little group chat where Karen Reed's naked photos were being searched for. You know the saying about the apple falling from the tree. Ladies and gentlemen, we haven't even started talking about the taillight yet. You'll recall that at the very beginning of this case, you were introduced to no fewer than 5 CPD officers very early on who searched the scene. None of them, not a single one, found any taillight material at the scene. 0. Stephen Seraph, Sean Good, Stephen Mullaney, Michael Lank, Paul Gallagher, they were all there. They were all walking right around there. They were all looking. They were searching with their eyes. They were searching with their hands. Some said they were searching with their feet. They even used tools, a leaf blower. Not one piece of bright red taillight material was at the scene, not a single piece, but incredibly, over the course of the next 3 weeks, according to Michael Proctor, 47 pieces of taillight material would end up being found, some of which were the size of a salad plate. The CERT team shows up later on January 29th, and according to O'Hara, the first few pieces of taillight were found about 5:45. And here's some interesting testimony that you heard. Who else was there? Who did O'Hara say was there? Well, he said his team was there. We certainly expected that, but then he said there were others. These other mysterious figures, some from Canton PD, some from the Massachusetts State Police, that he could not account for. Heavy coats, big masks, hats. Even Lieutenant O'Hara could not tell who was who, but he did note Canton police officers were there who were unaccounted for. Massachusetts state troopers were there unaccounted for. And during that search that was overseen by Trooper Tully, Proctor's supervisor, 3 pieces of taillight material were found. That's super important, and I want to concentrate on that for a second. O'Hara said all 3 pieces were in an area about 12 inches square. That's an area about as big as your dinner plate. Tully, however, claimed that 1 red piece was found. About 3 feet away from that was a shoe. About 1 to 2 feet from that was a clear piece of plastic, and a few feet away from that was a red piece of plastic. So we have red, clear, and red over the span of about, added up, probably 10 or 12 feet. Ladies and gentlemen, both of those things cannot be true. Somebody is taking liberties with the facts. Then Lieutenant Tully comes to court and makes this big grand gesture of opening all these evidence bags. These 2 evidence bags in particular represent exactly what we're talking about, those 3 pieces, red, clear, red. They're marked, they're sealed, they look official. They're not Stop and Shop bags, thank God. At least they've moved up from that. They've even got evidence tape on them. Who knew?
Is that guy in the back behind Jackson, is he face palming? He's a prosecution lackey. That's why he's sitting with the O'Keefes and not with Karen Reed's camp. But when he just heard him say Stop and Shop bags, at least they moved up from that. They moved up from Stop and Shop bags. I think he face palmed.
Evidence tape around here.
That was kind of funny.
So this must be real evidence, right? It must be real evidence in this case. And after making that big theatrical display, he opens up the bag with the red pieces and he pulls 2 pieces out. That's okay. Put the 2 red pieces together. Good so far. Then he opens up the second bag under Mr. Lowley's questioning. And you remember, he hesitated just a second. Opened that bag and pulled out 1 piece of clear plastic. Then pulled out a second piece of clear plastic with no explanation as to how that could have possibly happened. And he quickly returned all 4 of those back into the bag, sealed them up, and we're done for the day. The next day, I asked about that evidence again. I asked him to open up that bag with the red pieces, and he did the same thing. Pulled out 2 red pieces of plastic. And I said, you'll recall this, I said, look deeper, look closer, sir. Pull everything out of that bag. Would he have had I not suggested it? And then he pulled a 3rd piece of red plastic out of the bag. So miraculously, Trooper Tully's 3 pieces of plastic became 5 pieces of plastic right before your eyes. Ladies and gentlemen, the forces at play that multiplied those pieces of plastic inside those evidence bags are the same forces at play that multiplied the pieces of plastic at 34 Fairview. Think about that. Let that sink in for a second. How easy is it? That's not sloppiness. That's evidence manipulation. That's how, over the course of 3 weeks, those pieces of plastic go from 0 to 3 to 5 to 47. Ever increasing in size with every single search. Now, knowing all that, ask yourself the looming question, who had access to that taillight, the cracked taillight? Who was it? Go back and watch the Sally Port video. I'll give you the timestamp, 5:37. And see it for yourself. We know that Trooper Proctor, with binder in hand, walked by himself. Once we corrected the video from being inverted, you can see that he walked back by himself to the right rear tail light where nobody could see what he was doing. Higgins' own key swipes put him in the Sally Port that same afternoon and evening.
Right.
And then the Sally Port video magically skips and Chief Berkowitz appears right next to Proctor at the back of that vehicle in the same spot, and they walk out of the Sally Port together. Where were they going? Remember O'Hara? Unidentified troopers in Canton cops were at the search at 34 Fairview. How hard is it to drop a piece of plastic? We spent a long time talking about the compromised and altered and tampered and manipulated evidence, and now I want to switch and talk a little bit about the true facts in this case, because you did hear some true evidence and true facts.
Here we go. So up until this point, Jackson has been setting the stage, right? This is part 2 of a 2-part series. If you've not seen the first part of Jackson's closing, you have to see it, especially the beginning. It is absolutely magnificent, and I know I'm biased, it's my commentary, but I have some excellent commentary to fill in the gaps for you all who may be just joining us and are not familiar with the case. Now, after 45 minutes or so, 46 minutes of closing, Jackson is about to drop the hammer. Okay, he's got, as I told you before, Jackson has only 1 hour to do his closing, and we are about 3/4 of the way in. He's barely got 13 minutes remaining in his closing, and now he's about to drop the hammer. Now, listen to how Jackson sets up his argument and how he finalizes his closing in the Karen Reed case about an hour before the jury goes back to deliberate, because they still have to listen to Lally, unfortunately, for an hour. But right before they begin their deliberations. Oh, and I'm sorry, and the jury instructions. This one was really weird, by the way. This is not common, at least in the way that I've been practicing law. The jury instructions are often used by the defense and the prosecution in our closing. We use it all the time. As you have heard, the judge just instruct you is a phrase that I've used more times than I'd like to admit. The judge instructs the jury, the defense closes, and then the prosecution. Some states, I believe like California, the prosecution closes first, then you have the defense, and then the prosecution rebuttal. I've seen that. Some states do that. But the majority of states, I believe, are like Massachusetts. Massachusetts is like this. Kentucky is like this. We know South Carolina from the Alec Murdaugh trial is like this. Florida is like this. I believe you do closings for the defense first, and then you do prosecution. And then in the minute the prosecution finishes their closing, the jury goes out to deliberate. The fact that Auntie Bev, by the way, somebody called me out on this, someone who's represented Colin Albert, by the way. I don't want to call him by name, they don't deserve the recognition. We'll just call him corrupt lawyer number 1. Confronted me on Twitter publicly and said, how dare you a practicing attorney referring to a judge as Auntie Bev, that's because I have no respect for her. I do not respect this woman. She should not be a sitting judge. She is a danger and a menace to society, and she needs to be voted out. I have the utmost confidence that she's going to lose her next election, but the problem is we got to get there first, because state judges are elected, not selected like federal judges. So her full title is the Honorable Beverly Cannoni. I cannot call her honorable. I cannot call her judge. The way she's been acting has been so favorable to the prosecution and the Alberts and the McCabe's that it is sickening. It makes me want to vomit that this is what we're supposed to call justice system. This is the just us system, and Auntie Bev is a part of it. So Auntie Bev, and I'll continue calling her Auntie Bev until she changes her tune, which I don't think is ever going to happen, instructs the jury after the closings are concluded. I don't know if it's a narcissistic thing, if this is a Massachusetts thing, if this is an Auntie Bev, this is my courtroom thing, but there you have it. It is what it is.
The Commonwealth presented about 67, maybe more, witnesses and expended 30 plus days of trial and 9 weeks of your life. Maybe we're in the 10th week. For what? It should be relatively simple. That's what the evidence actually shows. The Commonwealth knows that, and they've known it for a long time, and Proctor knows that. And because of that, the Commonwealth just resorts to character assassination and talking for weeks on end about the snow. Let's talk about what the real evidence actually shows, the unassailable science. But the evidence and the truth goes far further. We introduced you to not one, but two thoroughly credentialed medical examiners, or medical experts, Dr. Sheridan and Dr. Russell, both of whom said John's arm injury is consistent with an animal attack. Dr. Russell studied, diagnosed, and treated up to 1,000 animal wounds. She's an expert in animal wounds, and she was unequivocal. Those wounds are from an animal, likely a large dog, which means that John was attacked inside the home where Chloe was. There is no other possibility. And Dr. Sheridan, for his part, with thousands of 13,000 autopsies under his belt, decades of experience as the chief medical examiner who's triple credentialed in anatomical, forensic, and neuropathology, he told you that John's injuries are inconsistent with a motor vehicle accident or incident. They're consistent, however, with a physical altercation. In layman's terms, the science proves John was beaten. That also is reasonable doubt and should end this case. But the facts and evidence don't stop there. Two of the most highly educated and highly qualified engineers you'll ever meet, Dr. Dan Wolf and Dr. Andrew Rentschler, mechanical engineer and a biomechanist. They reviewed this case.
From ARCA.
They did testing, they did analysis, they evaluated the case scientifically.
The FBI guys.
They were not hired by the defense, not by the Commonwealth. They're completely 100% independent.
And by the way, completely 100% independent, not hired by the government or the defense is a phrase I don't think I have ever heard before in my entire career as a litigator. You always have experts on both sides, and they're always hired by one side or the other. You never have an independent party just randomly stepping in and saying, oh, hey, we're just going to investigate this real quick. I hope you guys don't mind. Like, that's the feds. The feds are interested in this. They're investigating this. There may be some indictments coming down over the next few weeks or months. The feds don't screw around. They don't put on half-ass cases. If they're going to go all in, and they're going to go in hard. And when the shoe drops, pun intended, when the other shoe drops, you will see some serious damage done to the Albert and the McCabe families. Because once the feds get a hold of you, that means they have something. They never move in blindly just to see what happens.
Of any party in this case. And they were equally available, by the way, to the Commonwealth. They could have called them. They explained that John's injuries were not caused by being hit by Miss Reed's SUV, and that the SUV was not damaged by coming in contact with John O'Keefe's body. That should end the inquiry right there. Both sides of the equation. From a physics, engineering, and biomechanical standpoint, they established that John O'Keefe was not struck by Karen Reed's vehicle, period. And that is yet another fact that establishes reasonable doubt and should put an end to this case. So instead of calling the ARCA experts, which they had available to them, the Commonwealth chose to introduce you to Trooper Joe Paul. You'll remember his testimony.
Oh, God, Trooper.
I think I'm being kind when I say that Trooper Paul's analysis lacked credibility.
That's lightly put.
Trooper Paul lacks the experience, the education, the training, the background, and the knowledge to not only render opinions on these issues, but to even understand the issues themselves.
Yeah.
He makes the absurd claim that John was hit on the elbow area of his arm by a taillight. He was spun to the left in a pirouette. His arm stayed on the light long enough for the shards of plastic to explode around him, scratching his arm even though he was wearing long sleeves, then projecting him 30 feet to the left, but not before making a stop to hit his head on either the curb or the pavement before coming to his final resting place with his unbroken phone tucked neatly under his body.
That, my friends, is called cop science. It's bogus. It's BS. It's insanity. And yet, they take the stand and they testify with a straight face. Welcome to life.
It's nonsensical. It borders on laughable. Compare that testimony to Dr. Dan Wolf and Dr. Andrew Rentschler. Both PhDs in engineering, both top of their field in accident reconstruction, both published peer-review articles on the issues. Both men are highly sought after by the likes of national sports leagues and the United States Department of Defense. And these men are unrivaled in accident reconstruction. What did Dr. Rentschler say before he left the stand? This was even under cross-examination. He said that the physics and the science don't lie. His words were, "You can't deny the science and the physics." John wasn't hit by that car, period. The Commonwealth cannot explain John O'Keefe's injuries. They can't explain his head wound. How did he get the head wound if he landed on snow-covered grass and dirt? And by the way, before Mr. Lally gets up and says it, because I know he's going to, there is zero evidence before you, zero, that cold grass and dirt turns into ice or turns into concrete. Zero. They can't explain the injury above his right eye, that laceration. They can't explain his nose. They haven't even tried to. They can't explain the injury to his tongue, the laceration on his tongue. They cannot explain the injuries to the back of his hands, the bruises, and certainly they cannot explain the injuries to his right arm. But maybe most importantly, they cannot and haven't even tried to explain the lack of injuries on John's body from the neck down.
Right.
Nothing.
No broken bones, no fractures, nothing. How do you make car, human body, impact, zero injuries? That is the most staggering thing I've ever heard of. And there it is. Jackson's talking about it.
He was pristine. Not a bump, not a bruise, not a fracture, not a broken bone. Nothing to suggest that he was hit by a 7,000-pound SUV going 25 miles per hour. And what of that right arm?
5 minutes, Mr. Jackson.
Thank you, Your Honor.
That's the 5-minute warning from the judge that Jackson has 5 minutes remaining in his closing argument.
As he continued, he got hit, a punch went through, and he fell to the ground, fracturing his skull. At some point during that altercation, the dog got a hold of him, and the dog was pulled away. Every single injury is answered. Every single injury is explained by that. Ladies and gentlemen, given what we know about the facts and the physical evidence in this case, the actual truth in this case, how did this happen? How did we end up here? We ended up here because of relationships, insider trading, playing the who you know game, and building a tall blue wall, which takes decades and generations. But the real question is it going to continue? Will this festering malignancy that allows a lead detective and his supervisor to gloat and sneer while looking over naked pictures or looking for naked pictures of the woman that they've targeted, will that continue? And the answer should be, not if you have anything to say about it. Michael Proctor is the lead investigator in this case, and much as the Commonwealth might try, they cannot distance themselves from the stench of him on this case and this investigation. Those secret group chats, illustrate the quality and character of his investigation. Remind yourself how an, quote, unbiased and an objective investigator, someone who's supposed to be looking for facts. Ask yourself, how did he approach his job? Late at night, sitting there in his office, deviously looking for naked pictures of Karen Reed and talking about her like she's a piece of meat. Talking about her bodily functions, her medical.
By the way, if you haven't seen the Proctor series, as of this recording, I believe there are either 6 or 7 episodes that have already premiered, and there will be about 4 or 5 more. So there's a Jennifer McCabe series that's got 11 episodes. They've all premiered of the cross-examination by this same man. And we have the Proctor series, which I will conclude in the coming days before I go to the Alec Baldwin jury trial in Santa Fe, New Mexico, which begins on July 9th.
Conditions, calling her vile names. I don't even have it in me to repeat what he said about her. He reduced her to an object, and he went further by insulting her. He went further than insulting her, and he dehumanized her. And when he was done betraying that very humanity, he wished for her to commit suicide. That, ladies and gentlemen, is how you frame someone. That's how you dehumanize someone so viciously that you can just pin it on the girl and cover for the homeowner because he's a Boston cop.
Yep.
That's how you rip a person's life apart and sleep like a baby while doing it. And then further that by saying, I hope she kills herself. Ladies and gentlemen, I just began the discussion this afternoon or this morning with a quote about the truth, and I did that because that's what this case is about. Top to bottom, tip to tail, it's about the truth. Not hiding it or concealing it, but exposing the truth. The truth is immutable. It's not a feeling, it's not a whim. It's unflinching, it's unchanging, and it's everlasting. That's why the law is steady. That's why it's not captive to the whims of people drunk with power who think they're above the law, who think they're above scrutiny. That's why you stand as the guardian of justice and the protector of justice. The law demands the very integrity that Trooper Proctor and his investigation lacks, and it requires that you cannot convict Karen Reed unless the Commonwealth has met its incredibly high burden to prove every element beyond a reasonable doubt and to a moral certainty.
I want to say something about this. I know Jackson only has an hour and there's a lot of ground to cover, but beyond a reasonable doubt, I think should have been hammered home a little bit better. Again, I've said it in the previous video. Far be it from me for criticizing this man in any way, shape, or form. And don't take this as a criticism. Take it as a what I think could have been done better. You see, one thing that I feel maybe Jackson not missed, but didn't fully capitalize on, that he should have and could have, is the simple fact that Jackson is from Los Angeles. Los Angeles is a very, very big place. I believe the population of the city of Los Angeles is about the population of the entire Commonwealth of Kentucky, 6 million people. Canton, Dedham, Massachusetts, is a small place. People are simpler. Maybe there's some, maybe even farmers on the jury. I know there's at least one, like, computer, not engineer, analyst or something, I was told. I remember him being pointed out to me because he seemed very, very knowledgeable about certain things related to computers and computer-like stuff. Anyway, I think you can't hammer it home too hard, because if all you talk about is reasonable doubt, there's reasonable doubt, they're going to convict your client. You need to talk about the facts. You need to talk about the not guilty evidence. But those words, beyond a reasonable doubt to a moral certainty, and I love that he added that language. I've never heard that language before. Beyond a reasonable doubt to a moral certainty. I might start using those words, because we can't define reasonable doubt in Kentucky. I don't think you can do it in Massachusetts either. Some places you can, like the Carolinas, and I believe California you can define it. But yeah, believe it or not, in Kentucky you cannot define to the jury what reasonable doubt is. They have to literally decide what it means to them on their own when they deliberate. And God forbid you try to define it, a mistrial will be declared like that. I've had that happen actually in one of my own cases many, many years ago when I was still learning about the law and how to practice it. And so you have to understand that beyond a reasonable doubt is the highest standard in the land, and it is a very, very difficult burden, pun intended, to meet for the government. And so it's unfortunate that Jackson didn't, I'm just going to chalk it up to didn't have the time, Because if Auntie Bev had given him maybe a couple of hours instead of an hour, maybe 3 hours instead of an hour, he would have had time. But unfortunately, he only had 60 minutes, and there's only so much you can accomplish in 60 minutes. But I think that whole point about hammering home that reasonable doubt, there is so much reasonable doubt. That's all you need. If you have reasonable doubt, you must acquit. That's it. End of story. Remember Johnny Cochran. If the glove doesn't fit, you must acquit in the O.J. Simpson trial. And the jury acquitted, even though there was plenty of evidence pointing to his guilt. Back then, DNA was a fairly new phenomenon, a fairly new invention, so the jurors were completely blindsided. They didn't understand what they were looking at. They didn't know how trustworthy it was. They didn't realize it was completely infallible. Here, of course, there's barely any DNA evidence, and the ones that we have is shoddy and useless. But, I don't know. I think hammering home reasonable doubt beyond a moral certainty could have been done a little bit better, and maybe with a little bit more oomph and panache, and repeated a few times. People need to be repeated these things multiple times in order for them to understand them. This is the standard. They have to meet it. Otherwise, he's opening the door, and prosecutors like to do this to me all the time. Folks, this is a quote, just use your common sense, end quote. And I always object to this, at least these days, that's the government trying to lower the standard from beyond a reasonable doubt to common sense. And they must be held to that standard. Prosecutors must be held to the standard of beyond a reasonable doubt, because if you bring the standard down, I believe at least one time in my career, one of my clients got convicted because the jury trusted him, listened to him, and lowered the burden to common sense. The defense does not have, or tried to shift the burden onto me. I think it was more he tried to shift the burden onto me. You didn't bring this, you didn't bring that, you didn't bring this. I definitely had a hung jury happen that way one time, and luckily we ended up winning the case because the prosecutor caved after a year of negotiations, and he ended up dismissing the case. But at the trial, he got 3 jurors to flip, literally in closing arguments, because he shifted the burden, and I didn't know what was happening. I didn't quite understand it at the time. I understand better now. We had a jury trial just earlier this year in Jefferson County. My associate and I, he was leading the fray. I was giving him the floor. It was his case. And the prosecutor, in closing, started talking about common sense, folks. Just use your common sense. Oh, and I objected strenuously. And I even asked for an admonishment from the judge, because that's how important it is. Reasonable doubt is a very, very high standard. It's a very powerful standard. It is an extremely high standard. It is the highest standard in the land. It only applies to criminal cases and criminal convictions. And Alan Jackson, I think, could have done a little bit better with it. But it is what it is. Let's finish it up.
And a moral certainty is defined as the highest degree of certainty possible in matters related to human affairs. It's the highest degree possible in your life. That's the level of certainty. And I'll leave you with this. You have the most powerful tool known to American jurisprudence, because you have your vote. No one can take that away from you. Not me, not the Commonwealth, not the court. You may not have asked to be here, but each of you have given something very special of yourselves. You've agreed to do that which is the highest calling a citizen can answer in any way. You've agreed to give your community your best. And my question to you is, what will you do with this moment? Ignore the lies and the manipulations, the misogyny, the bias, the lack of evidence? Could you ever do that?
He's empowering
Would you ever do that? Or will you say with your verdict, I see the truth, and I will not ever look the other way?
And there it is. He just brought the theme right back. I, the juror. Yes, they're asking me to look the other way, but I, the juror, will not look the other way. It's very powerful. He's empowering the jury, and he's using his theme. It doesn't get much better than this, folks.
When you stare the truth down, you'll see that the Commonwealth has not proven its case beyond a reasonable doubt into a moral certainty, not even close. Ladies and gentlemen, Karen Reed is innocent. Do justice and find her not guilty. Thank you.
All right. Thank you very much, Mr. Jackson.
What a closing. What a magnificent, beautiful way of utilizing words in order to sway individuals to take the position of justice, truth, and not looking the other way. I mean, it, like I said just a second ago, it doesn't get much better than this, folks. This is one of the top litigators that this country currently has. This is the creme de la creme, the best of the best. As I've said in the previous video, this is a man who has defended the likes of Kevin Spacey and has gotten acquittals. He's represented Harvey Weinstein, and they're actually just won on appeal in New York on his conviction from a few years ago, and they are appealing his conviction in Los Angeles. And from my conversations, my personal conversations with Alan Jackson, he said that he believes that those will be overturned as well in Los Angeles due to too many violations of the law. And you know what? I believe the man. A very powerful litigator. This has been another masterclass series. We will do more of these, folks. I hope to do Camille Vasquez in the Amber Heard case and Johnny Depp. I want to do the cross-examination of Amber Heard masterclass series by Camille Vasquez, because that was absolutely stunning. I was in the courtroom for that, so that's going to be fun to maybe my face will pop out there again. Then also the Kyle Rittenhouse, I think it was like Officer Grosskreutz, if I'm not mistaken, if I'm pronouncing that correctly. I want to do the cross-examination there and the closing for the Rittenhouse case. You know, that jury deliberated for 27 hours before they acquitted. So anyway, I'm going to leave you with that, and I will see you all back with Michael Proctor, which will premiere probably tomorrow or whatever the next day is. Once we conclude Michael Proctor, we'll see where it takes us, because Alec Baldwin is coming up on July 9th. 2024, and that's going to be next. I'm personally going to be in the courtroom. Chandler is going to be streaming, and there may be some days when we will switch, but for the most part, I'm very excited to be in New Mexico for this event. We have a media seat that's officially confirmed by the Administrative Office of the Courts, and I am very excited. So we'll see you guys soon. See you all tomorrow. Bye, everybody.